Hello and welcome to Byjus Exam Prep IAS. Before we start with our today's analysis, we have an announcement. Byjus Exam Prep IAS is happy to launch our Telegram channel. What is that you have to do? Scan the QR code or link will be given in the description box. This will take you to the Telegram. So join the channel to get all the updates about the initiatives of the Byjus Exam Prep IAS. So this will be an initiative which will be launched from tomorrow, which is 1st of August. Let's get started and look into the first article. The first article says, what has the Supreme Court said on PMLA's validity? Let us try and understand what is this article all about. We have one of the important legislations in our country, which is nothing but Prevention of the Money Laundering Act. What is this Prevention of the Money Laundering Act? What is money laundering has been explained previously in our CNAs. But what will be the focus of discussion? The focus today would be primarily on the judgment passed by the Supreme Court of India. What was this judgment all about? There were a number of petitions that was filed in the Supreme Court of India. These petitions were with respect to whether there are some draconian sections which are present in the PMLA. It also looked at working of the Enforcement Directorate as well. Why? Because the Enforcement Directorate had too much of powers which according to the petitioners were being used as per the whims and fancies of the Enforcement Directorate, and at the same time the government was misusing the Enforcement Directorate as it was used only against the opposition. So all these allegations were made on the PMLA draconian provisions as well as on the Enforcement Directorate. So the Supreme Court looks into all these arguments put forward by the petitioners and has ultimately concluded in favor of the government. So in this particular article, we will try and understand some of the important observations made by the Supreme Court of India. When we look into why the PMLA was introduced, during the mid 1980s, there was a global concern. What was this concern? There were people who were engaged in illegal activities. There were people who were getting money from terrorism. There were people who were getting money from human trafficking. There were people who were using their money that is from all these illegal activities. So they are laundering their money, converting this illicit money, the black money, into the white money. So what the global community decided is we have to bring an end to this money laundering concept where the black money was being laundered, was converted into white money. So what does the global community do? The UN Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances, adopted in Vienna in 1988, which is also called as Vienna Convention with respect to illicit traffic, was the first treaty that called upon nations to adopt domestic laws to combat drug trafficking. What does this mean? This means that there were active groups who were engaged in drug trafficking. They made money from the drug trafficking. They converted this black money into the white money. To prevent this, what we required is the global cooperation. The Financial Action Task Force was established in the G7 summit in Paris in 1989 in response to mounting concerns over money laundering. So the task force did also make recommendations to the national governments as well, that we, the Financial Action Task Force, have identified the criminal activities. So to prevent these criminal activities, we have some suggestions and reforms. These were suggested to the countries, and the countries' governments were able to bring reforms as well. The UN Convention Against Transnational Organized Crime of 2000, Palermo Convention, also advocated legislative and other measures to combat organized crime and specifically called for criminalizing the laundering of proceeds of crime. So all this meant that there was something that was happening at the international circle, but we also required a law at the national level. So the international circles wanted these countries, that is wherever these issues were perpetuated, to come together so that we bring an end to the issues of money laundering. And as a result, because India was signatory to these conventions, India came up with a law called as the Prevention of the Money Laundering Act. So what is this Prevention of the Money Laundering Act? It was enacted in 2002, came into force in 2005 because India was signatory to these international conventions. We had an obligation to keep up to all these legislations. And now there have been number of petitions in the Supreme Court of India about this particular legislation. Let us try and understand what are these observations made by the Supreme Court of India and what were the petitions speaking about. When we speak about the first issue is with respect to enforcement case information report. What is this enforcement case information report? Let's say for example we have a cognizable offense. What is this cognizable offense? Let's say a murder is committed or a rape is committed or a heinous activity is committed. In all these cases, what the police officers do, they need not have to ask the permission of the magistrate. They can directly go to this particular scene or a circumstance and they can make an arrest. So for all cognizable offenses, the police register what is called as the first information report. So the first information report is registered by the police officer whenever there is a cognizable offense that is committed. And whenever it is a non-cognizable offenses, what will happen? The police will register what is called as the non-cognizable report. This is what happens in the criminal justice system. Now what happens with respect to the enforcement directorate? The enforcement directorate will start investigating a money laundering case. So whenever it is investigating a case, it will register what is called as enforcement case information report. So the police officers file what is called as FIR for the cognizable offense, and if the enforcement directorate is investigating one of the money laundering cases, so it is called as the enforcement case information report. What was the issue with respect to enforcement case information report? So whenever this is registered by the enforcement directorate, whatever was happening was not given to the accused. Whenever there is a police officer who arrests you for the cognizable offense, an FIR copy is given to the accused. But this is not the case when it comes to the enforcement directorate. The enforcement directorate make this enforcement case information report, but ultimately it was not given to those people who were accused. So the petitioners go on to the court of law. They say that this is not right way to do it because there are police officers who are giving the FIR. Why not the enforcement directorate give this enforcement case information report to the accused? This was one of the appeals that was asked in front of the Supreme Court of India. But now the Supreme Court of India has said that supply of a copy of ECIR in every case to the person concerned is not mandatory, and it is enough if the ED at the time of arrest discloses the ground of such arrest. So the Supreme Court has gone in favor of the government, and it has clearly said that this ECIR copy need not be given to the accused, but whenever the enforcement directorate is making an arrest, they have to give the grounds. That is more than enough, says the Supreme Court of India. So does this mean that there is violation of the liberty? Maybe. We'll continue with this. Then we have one of the important sections. Section 5 speaks about attachment of property involved in money laundering. What does it say? Any person is in possession of any proceeds of crime. What is this proceeds for crime? Let's say for example there is a person who is engaged in drug trafficking or he is engaged in terrorism. So he takes the money from this particular activity. So the money that is extracted because of narco terrorism or criminal activities is what is called as proceeds of crime. He's committed a crime, he's got the money, that is what is called as proceeds of the crime. Such proceeds of crime are likely to be concealed, transferred or dealt with any manner which may result in frustrating any proceedings relating to confiscation of such proceeds of crime. Under this chapter, he may by order in writing provisionally attach such property for a period not exceeding 180 days from the date of the order in such manner as may be prescribed. What do we mean by it? Let's say for example there is a person. The enforcement directorate basically believe that this person had engaged in a criminal activity. He has taken this particular money and has invested in a property, or he has bought a house, or he has bought any of the tangible properties as well. In this particular case, the enforcement directorate confiscate this house or a farmland or any other tangible property. It is at this particular point the petitioners ask a question to the Supreme Court: is it right to do so. So the Supreme Court says yes, it is right to do so because they have ample amount of opportunities to be heard in the court of law as well if the accused feels and if he is able to show that this particular property is taken not from the crime proceeds but from elsewhere, from any other business. In that case, he would be given back the property, he would be released as well, and his property will not be taken by the enforcement directorate. So the Supreme Court has clearly clarified that it provides a balancing arrangement to secure the interests of the person as well as to take care of the sovereignty of the country, integrity of the country, because this proceeds may be used for illegal purposes in the near future. So there are enough procedural safeguard to protect the interests of the person and at the same time take care of the provisions of this legislation, said the Supreme Court of India. This is the second argument. The third is with respect to power of search, seizure and arrest. The bench also upheld the ED's power to carry out the search, seizure and arrest under section 17, 18 and 19. The bench also said that these provisions have stringent safeguards and do not suffer from the vice of the arbitrariness, says the Supreme Court of India. And then we have section 24, which speaks about burden of proof. What is this burden of proof? When we speak about the criminal justice system, let's say we have a criminal case. Whenever we have a criminal case, there are two parties. One, what we have is the prosecution. The prosecution is usually the state. The state stands for the victim. Then you also have the defendant, who also means the person who's committed this particular crime. So you have the prosecution on one side, you also have the defense on the other side. So who is bringing this case in front of the court of law? It is the prosecution. So in most of the criminal cases in India, it is the prosecution which has to prove to the court of law that it is this accused who has committed this particular crime. So the burden of proof in most criminal cases is on the prosecution, but there are some exceptions as well where it is the defense who is the accused who has to prove to the court of law that he or she has not committed this particular crime. Let's say for example, we have the POCSO Act, we have the SCST Act, we have the NDPS Act. In all these acts, what we have is the defense and the accused who have to prove to the court of law that they haven't committed this particular act. So even in this particular Prevention of the Money Laundering Act, the burden of proof was on the accused. So the accused has to prove to the court of law that he hasn't committed this particular mistake. So is it against the normal criminal justice system? Maybe, but the court has upheld that this is required so that we can maintain the sanctity of this particular legislation and also oblige to the obligations of the international conventions. In any proceedings relating to the proceeds of the crime under this act, in the case of a person charged with the offense of money laundering under section 3, the authority or the court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. So the accused has to prove to the court of law that whatever proceeds have got is not through the money laundering activities but by the legitimate businesses. In the case of any other person, the authority or court may presume that such proceeds of crime are involved in money laundering. So it is for the accused to prove it. So the Supreme Court in this particular case has gone ahead and said that the validity of section 24 is right, which puts the onus on the accused to prove that the proceeds of crime are not from the tainted money, and the Supreme Court has clearly said that there is reasonable nexus with the purposes and objectives sought to be achieved by the PMLA and cannot be regarded as manifestly arbitrary or unconstitutional, says the Supreme Court of India. Then what we have is section 45, which speaks about the bail provisions. When we speak about the bail provisions in the PMLA, we have what is called as the twin conditions. What exactly happens in the normal circumstances if there is the accused and there is the court as well? So whenever a person is filing a case in the court of law and he wants a bail, it is only the accused and the court who deal with it. But what happens in the present situation in the PMLA? You also have the public prosecutor who can oppose it as well, that the public prosecutor shall be allowed to oppose the application for release. Where the public prosecutor opposes such application, condition, the court should be satisfied there are reasonable grounds for believing that the accused is not guilty of the offense and that he is not likely to commit any offense while on bail. So when we speak about the twin conditions, one, the court should feel that there are reasonable grounds for believing that the accused is not guilty of offense of money laundering. First point. Second point is that the accused is not likely to commit any offense while on bail. If these two conditions are satisfied, only then what we have is bail granted to that accused under the PMLA. So in the year 2018, the Supreme Court had struck down this section as it was originally worded on the ground that the conditions only applied to those listed in the Part A of the schedule, attracting a prison term of 3 years and more, but not for the offence of money laundering itself. However, the Parliament re-enacted this section with a change that the conditions would apply to all cases under PMLA without any reference to the schedule offence. So the Supreme Court in this particular case, when asked before the Supreme Court, has gone ahead and said yes, the Parliament has the power to enact a provision to cure a defected law, and as a result the parliament has brought about a change. And when we speak about PMLA, which is to do with the money laundering, it does not only impact the socio-economic fabric of the nature but also tends to promote heinous activities. What are these heinous activities? Drug trafficking, terrorism and multiple other issues. There is a larger international criminal network as well. In order to prevent this, in order to make sure we bring an end to all this, what we have as a bail provision, which is twin provision, is a necessity, says the Supreme Court of India. And finally, it has also put a word on the ED summons as well. Whenever a summons is issued by the Enforcement Directorate, the Enforcement Directorate has all the power of a civil court. So the Enforcement Directorate can summon that particular person to be a witness, give a statement in that case, or they can also summon as an accused as well. So whenever they are summoned, they are supposed to give the statement, produce the documents which are mandatory in nature, and if they have to speak something and this happens to be a false statement, that is equivalent to that of perjury as well. In this case, the Supreme Court has said ED officers were not police officers and the proceedings related to summons being only an inquiry related to proceeds of the crime do not amount to an investigation. Therefore, it was open to the ED to gather material without treating the person as an accused, but nevertheless prosecute him later if the information gleaned disclosed a money laundering offense. So number of questions were asked before the Supreme Court of India, and the Supreme Court of India has clarified all these issues that the petitioners had asked with respect to the Supreme Court of India. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says new e-waste rules threatens jobs collection network. What is this electronic waste or the e-waste? This refers to all those items of electronic and electrical equipment and its parts that have been discarded by its owner as waste without the intent of free use. Let's say for example you have a mobile phone. Let's say you have a mobile phone which is Nokia 1100. Who would not have used it? So this phone, because you have a smartphone, you may not be able to use it or you wouldn't wish to use it. So this 1100 which you're not using, which you never want to use in the near future, will become an electronic waste. So an electronic waste is considered as a waste electrical and electronic equipment, and this is the e-scrap that has been accumulated world over. When it comes to the electronic waste or the electronic goods, what exactly happens after a particular period of time? You would start chucking it. So once you start chucking it, this will obviously become a pollution if it is not treated. It can harm water. It can also have soil pollution as well. This can also have water pollution as well. This ultimately had to be regulated. So the government decides that what we require is the complete regulation of this particular sector, and as a result what it introduces introduces is the e-waste management rules of 2016. So when it comes to this particular sector, there were large number of people who were working in the e-waste, but unfortunately it was not regulated, and most of the people who were working were also in the informal sector as well, and added to it there was child labor which were employed, and these people were unskilled laborers. They were working in unhealthy and unsafe conditions as well. So what the government of India decides, one, we needed laws to make sure that pollution does not happen, and at the same time we also have to regulate so that the rights of the people, the informal sector people, their rights are also taken into picture. To address all of this, it comes up with e-waste management rules of 2016. According to this e-waste management rules of 2016, it introduced a concept which is called as extended producer responsibility. So what is this extended producer responsibility? Who is a producer? A Samsung is one of the mobile manufacturers. It manufactures mobiles, or let's say for example, you also have the MacBook, the Apple, which also manufactures its own share of electronic gadgets as well. So these two companies becomes the producer. So added to whatever they are manufacturing right now, they are given an additional responsibility. What is this additional responsibility? The additional responsibility is that they should also be able to regulate it. They should also be able to recycle their own products. So if Samsung is coming up with a mobile phone, and if this mobile phone after a couple of years is not being used, this should be taken back by Samsung and this should be recycled. So whatever parts that can be used will be taken off, and whatever cannot be used will be recycled by Samsung. But ultimately there was issue with this particular model. What was this? Why was this model not successful? That is because these mobile companies which were manufacturing, or any other electronic good companies which are manufacturing, they were not able to keep the records. So because they were not able to maintain the records, because they were not able to maintain these records for a longer period of time and for longer devices, for great number of devices, which is why the government introduces a new concept called as the producer responsibility organization. So what is this producer responsibility organization? We have the manufacturing entity. We also have people who are the recyclers. These are the people who would actually recycle it. So what you require is a bridge between them. So that bridge is what is called as the PRO, or the producer responsibility organization. And these producer responsibility organizations used to work with the consumers. They used to create an awareness. They used to enable a supply chain for the recycled goods, and at the same time they also used to bid the contracts with these mobile manufacturers or the electronic manufacturers, and ultimately make sure that all of these was recycled. If we look into the statistics, as of March, the Central Pollution Control Board has registered 74 PROs and 468 authorized dismantlers who have a collective recycling capacity of about 1.3 million tons. The Environment Ministry estimated 7,70,000 tons of e-waste to have been generated in 2018 and 19, and around 1 million tons in 2019 and 20, of which only a fifth, about 22% in both years, have been confirmed to be dismantled and recycled. So according to the existing system, what we had is the PRO, which is nothing but the producer responsibility organization and the dismantler. So the PRO was acting as an intermediary. You had the dismantler, you also had the mobile and the electronic manufacturing companies. But now what we have is a new notification released by the Environment Ministry, where it says that this PRO will be done away with, and these electronic companies can directly speak to the recyclers. So this intermediate part will be done away with, and what we will have is only the recyclers, says the new rule book. Why did the government come up with this particular change? That is because the current system, which is managed by the PRO, isn't always reliable, as there have been several instances of double counting where the same articles recycled for one company was also credited to some other company as well. So they were acting as a bridge, but they were giving the same certificate, same electronic goods that was recycled to different organizations as well as companies. So in order to prevent it, what the government of India has come up with a new notification. According to the new rules, recyclers will likely establish their own supply chains, and companies will no longer bear any responsibility for ensuring that their product is recycled. 5 years of investing and putting in place a system to collect and channelize waste was under threat, as about 25,000 to 30,000 were employed in this particular sector. PROs provide check and balance, and this is necessary because in the current system there is lot of unauthorized recycling. So as of now, what the PRO was able to do, the recyclers won't be able to do. The PRO was keeping a check on the dismantlers. Now there is no such check, so this could ultimately harm number of people, because the PROs were able to recruit number of people. They had given job as well. These people would audit the dismantlers, but that is not happening in the present case. So many people would suffer, says this article. But the latest rules which have been put up for the public feedback are expected to come into effect only from August, and meanwhile, if people are not happy with it, they would also be able to make suitable recommendations, says this article. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says activists press for new anti-trafficking bill. Let us try and understand what is this article all about. First, we have to understand about World Day Against Trafficking in Persons. This is celebrated every year on 30th. Why is it celebrated? That is because to raise awareness about the ordeal of the human trafficking, and also to safeguard the rights of these victims. So July 30th is celebrated as World Day Against Trafficking in Persons. The day has been marked ever since the year 2003 by the United Nations Office on Drugs and Crime. The organization has been incumbent in collecting data and information on human trafficking, and it has been able to prevent the crime while protecting the rights of the victim. What is trafficking in persons? When we speak about United Nations, it says trafficking in persons as the recruitment, transfer, transportation, harboring of persons by use of threat, means of force or other forms of coercion, deception, abduction, fraud or abuse of power, forced labor services, practices of slavery, sexual exploitation, among other forms combined, or what accounts for exploitation. What is the theme for the year 2022? The theme for the year 2022 is use and abuse of technology. What exactly happens? There are people who engage in these illegal activities of trafficking by making use of the technology. So they make use of the social media platforms, they make use of the internet. Why? Because their identity will not be disclosed and there is anonymity in it, and as a result, they keep waiting for their prey, and the minute they are able to get someone, they would be misusing this online platform. So the internet and digital platforms are used as a tools to recruit, exploit, control victims, organize their transport and accommodation, advertise victims, and reach out to the potential clients, and as a result, they are making use of the technology for the perpetuation of trafficking. In order to overcome this particular issue, what this article currently goes on to say is, while on one side they're using the technology for all the illegitimate purposes, why not we make use of the technology for the legitimate purpose? So the future success in eradicating human trafficking will depend on how law enforcement, criminal justice system and others can leverage technology in their response, including by aiding investigations to shed light on the modus operandi of trafficking networks, enhance prosecutions through digital evidence to alleviate the situation of victims in criminal proceedings, and providing support services to the survivors. Prevention and awareness raising activities on the safe use of the internet and social media could help mitigate the risk of people falling victim to the trafficking online. Cooperation with the private sector is important to harness innovation and expertise for the development of sustainable technology based solutions to support the prevention and combating of human trafficking, says this article. Added to it, countries will also have to take responsibilities as well. As of now, you have number of countries which are able to perform offline. So whatever activities they are able to perform offline to stop the illegality, the same should be happening on the online as well. So those people who are involved in the online trafficking, they should also be prosecuted. This is for the countries, and at the same time, there are technological based companies as well. These technological based companies will also have to make use of their own tools to fight the human trafficking and make sure that illegal and harmful material online is immediately removed from the online platform. These are some of the recommendations that we should be in a position to take up to prevent trafficking and that is on the technological platform, says this article. Further, this article makes a mention of the Trafficking in Persons Protection Care and Rehabilitation Bill of 2022. We would not be discussing this right now because we will have more updates on this. We will take them elaborately in the near future. So what are the causes of human trafficking? When we speak about human trafficking, poverty is one of the main causes of trafficking, followed by the social factors, migration, and there are other factors like the porous nature of borders, corrupt government officials, involvement of international organized criminal groups and networks, limited capacity of or commitment of immigration and law enforcement agencies to control the borders. And when we speak about the constitutional framework and laws in India, we have Article 23 of 1 of the Constitution of India, which prohibits trafficking in human beings and states that any contravention of this shall be a punishable offence. We also have the Immoral Trafficking Act Prevention Act of 1956, and we also have Section 370 of the Indian Penal Code, which speaks about the legislative framework to prevent trafficking in India. Now let's look into the next article. This article says speed up release of under trial, says the Prime Minister of India. The article goes on to say that we have the Prime Minister of India who goes on to say, when we speak about business, we have the ease of doing business. When we speak about living, we have the ease of living as well. Similarly, what we need to have is the ease of justice, and this is in specific emphasis to the under trials who are presently languishing in jails have to be provided justice as soon as possible, says the Prime Minister of the country. Now the question is, who are these under trials? When we speak about the criminal justice system in the country, whenever there is a person who is accused of a crime, this person is convicted by the court of law. What do we mean by conviction? That all the charges are proved. Ultimately, the accused is the person who has committed this particular crime. When all charges are proved and it is proved in the court of law, then conviction happens. So he have to serve for a particular period of time. But then there are people who are called as under trials. Who are these persons? Yes, they are detained in prison during the period of investigation, inquiry and trial for the offence that they have been charged of, but yet it is not proved in the court of law. So once it is proved in the court of law, he would be convicted for this particular period where it is yet not proved, but he is present in the jail. That person is called as an under trial. If we look into the statistics, what is the share of under trial in prison inmates? In Delhi, it is about 90.7% in 2020. It is about 90.5% in Jammu Kashmir plus Ladakh. In Bihar, it is about 85.1. In Odisha, it is about 82.7. And similarly, it also gives data about multiple other states as well. Now, if we have to consider for how many years they have been languishing, more than 80% for 1 year. This is about greater than 1 year. This red is for about greater than 3 years, and this yellow is about greater than 5 years as well. Amongst all these under trials, we have the illiterate, below class 10 and above but not graduates, graduates, postgraduates and technology diploma people. So if you look into the statistics, it is the illiterates and below class 10 who are mostly the under trials. According to the Prison Statistics India, published by the National Crime Records Bureau in 2020, there were as many as 4,88,511 prison inmates, of whom 76% or nearly 3,71,848 were under trials. This points out the bleak picture when it comes to the under trials. So what is the maximum period of detention for an under trial prisoner? When we speak about section 436A of the Code of the Criminal Procedure, an under trial prisoner who is not accused of an offence punishable with life imprisonment or death should be released if they have been detained for half the period of imprisonment prescribed for the offence. What are the problems that are faced by the under trials in India? There are no separate prisons for the under trials in multiple states. When you go to the central jail or the jails in India, you have separately what is called as the under trial section. You would also have something called as the convicted section. But in most of the jails in India, the article also says that we do not have such categorization. As a result, these under trials may be the accused. It is yet not proved in the court of law. So they will get in touch with these convicted prisoners, and ultimately in the near future, they may become hardened criminals as well. That is the first major concern. The second major concern is within this particular jail, there can also be group rivalries as well, and as a result, these people will further have human right violations. Third is with respect to the overcrowding. We know for the fact that Indian jails have a lot of overcrowding, and when we speak about overcrowding, what happens? There are people who are from the poor backgrounds, they're already not fed, they do not have nutrition, but when there is overcrowding, they have to sleep with many other people in this particular jail premises. They would not be able to have healthy sleep, they would not be able to get healthy food, they would not be able to have healthy nutrition as well. This ultimately is violating their other rights. Added to it, under trial prisoners also face homosexual abuse, as prisons are places where same sex people are lodged. All these are the issues with respect to the under trials. But what are the rights that are given to the under trials? When we speak about the rights, right to the speedy trial is one of the right given to the under trials. Right against inhuman exploitation, so any human rights that is violated cannot be taken up easily. They can say the same to the court of law as well. Right to legal assistance, they can also avail legal aid to assist them, and at the same time they also have the right to meet their family as well, but they have to follow few criterion whenever they are supposed to meet their family. But in the present situation, since the Prime Minister has said, there have been some measures that have been taken in the past. Mr. Rijiju informed Nalsa campaign to identify under trial prisoners who are eligible for release, will hold weekly meetings with an aim to release maximum number of under trial prisoners on or before August 15th. DLSS, that is District Legal Services Authority, have been mandated to hold weekly meetings of under trial review meetings to discuss progress review additional cases and to discuss further action, including filing of bails in the High Court and the Supreme Court of India. And the Prime Minister has also said that we are in the technological era. We already have a program called as the e-courts mission. The virtual courts are being started in the country, so with more e-courts in place, the court will expedite these under trials and ultimately they will be released, says the Prime Minister of India. Added to it, the National Legal Services Authority has taken a number of initiatives in the past, but it should now encourage the Bar Council to ask more advocates to get involved in the campaign for the under trial prisoners, says the Prime Minister. In fact, the District Legal Services Authorities can also take up the responsibility of providing legal aid to such prisoners, and these people should be released as soon as possible, is what is this article all about. Now let's look into the next article. This article says invasive frog and snake dent world economy. There were two invasive species, one that happens to be the American bullfrog, the other that happens to be is a snake, and this snake happens to be brown tree snake. This is also known as Boiga irregularis, and both these invasive species have caused a problem to the world economy. How? The snakes have at times been so abundant that they caused power outages by crawling on the electricity equipment, and at the same time they have also destroyed crops as well. This meant that it has hit the world economy, and the cost would be about 16 billion between 1986 and 2020, says this article. So on one side it has created crop damage, on the other side it has created power outages, says this article. Now let's look into the next article. This article says the next flashpoint in the US China contest. We have discussed about the Taiwan issue in our explain session. The link for the same will also be given in the description box, so kindly look into it. Now let's look into the mains practice questions. The Supreme Court verdict on the Prevention of Money Laundering Act fails to protect personal liberty from stringent provisions. Do you agree? Justify. Write a note on e-waste management rules of 2016 and examine how the rules proposed by the center threatens the livelihood of thousands of people. So please write all your answers on the comment section, peer review, and do give some positive feedback to your friends' answers. So this is it for today. Thank you for watching. All the best.